May it please the court. I'm Andrea Butler as a court-appointed amicus in opposition to the district court's opinion. The key question in this case is whether Mr. Zaharia-Shevitz is challenging an action that can be appealed to the MSPB. He clearly is for two reasons. First, he was granted an individual right of action under the Whistleblower Protection Act. And second, his constructive demotion amounted to a serious adverse employment action. I plan to focus primarily on the first reason today. The plain language of the statute provides that any action that is appealable to the MSPB and also partially motivated by impermissible discrimination creates a mixed case appeal and can be reviewed in federal district court. And an IRA appeal plainly is an action that is appealable to the MSPB. The statute does not say, as the government contends, that only actions listed in 5 U.S.C. section 7512 can qualify as actions that are appealable to the MSPB. It is clear that Congress intended employees alleging that they suffered grave enough adverse employment actions.
Assuming that we agree with you that this is a mixed appeal, how was it timely?
Sure, Your Honor. So I would address the government's contention about the 65-day deadline in a number of ways. First, that deadline is not applicable here. The OSC did provide Mr. Zaharia-Shevitz a letter dated May 7, 2018. However, that was after the 120 days allowed by statute for which the Office of Special Counsel had to act had passed. And so when those 120 days expired, he automatically had an individual right of action. And if you look at the letter in the joint appendix, which can be found at Joint Appendix 187 and 188, it's clear that the Office of Special Counsel itself did not think that it was triggering the 65-day deadline. It cited Section 1214 A1B, which is the provision that says whenever 120 days have passed, an individual right of action attaches. And further, the Office of Special Counsel did not take the actions set out by statute to even officially terminate its investigation. Within those same sections, within that same statutory section, the Office of Special Counsel must do certain things to issue an actual notice of termination, and it did not do those. It did not, as Section 1214 A1D requires, provide Mr. Zaharia-Shevitz a chance to provide comments before officially terminating its investigation, and it did not provide a written statement notifying the employee of the termination of the investigation, a summary of the relevant facts found by the Special Counsel, and its reasons for terminating the investigation. So it's clear from even the Office of Special Counsel's communications itself that the 65-day deadline was not intended to apply here. And further, I mean, even if the Office of Special Counsel can cite the wrong provision and still expect the deadline to apply, it should be equitably told here. The regulations clearly provide that this deadline can be equitably told, and therefore it can't be jurisdictional consistent with the government's argument. I mean, if the regulations can toll a provision and alter it, then it can't be jurisdictional for this court or for the MSPB to be able to exercise jurisdiction over that appeal. So I think that there are a number of reasons why that provision doesn't apply.
Ms. Butler, this Judge Diaz, are you conceding that the government timely raised these deadlines? Isn't there a question of waiver, assuming that these are not jurisdictional?
Yes, Judge Diaz, and that's exactly the point. The government did not raise the timeliness issue before the MSPB when Mr. Zaharia-Shevitz brought this appeal before the MSPB. In fact, the government explicitly filed a letter with the MSPB saying, we think now that you've pointed to these letters in the record, JA 187 and 188, that jurisdiction is proper here and this appeal should go forward. So that's not just forfeited, that's clearly waived. The government gave up this argument before the MSPB.
Well, it's forfeited or waived if in fact it's not jurisdictional, right? So what's the argument that it's not?
Sure. So it's not jurisdictional. One, because the cases that the government points to, for the proposition that it is jurisdictional, simply say, exhaustion in general is jurisdictional. And I don't think that we dispute that a federal employee is required to exhaust his actions before the Office of Special Counsel. However, this ticky-tacky 65-day deadline is not jurisdictional, and it clearly can be waived, as at least the Seventh Circuit has held in the Delgado case, Your Honor. And finally, I think it's an important point that the government itself, the MSPB, tinkers with this allegedly mandatory statutory deadline. Its own regulations provide for a 5-day kind of buffer zone that is different than the statutory 60-day deadline itself. And then the regulations also explicitly allow for equitable tolling. So I just don't think that something that the government itself says that it can tinker with is a jurisdictional requirement by statute. And I think that the case law supports that. The 65-day deadline should not be a bar here. And it can be equitably tolled. And, ultimately, it's just not even applicable in the first place.
So assuming we get beyond all of that, what is your argument for the constructive demotion and the fact that that is not specifically listed in the statute?
Sure, Judge Thacker. So I'll say first and primarily, this court doesn't even need to reach the question of constructive demotion if it agrees with our interpretation of Section 1221 and 7702, which allows for an IRA appeal to be a mixed case appeal. But a constructive demotion is something that can be a serious adverse employment action, because the idea that a constructive adverse employment, an adverse employment can be a constructive discharge or a constructive termination or something like that is well accepted in federal employee discrimination law. And in fact, the Federal Circuit itself has stated, in this context, under this statute, it's appropriate to recognize that a constructive demotion may be within the ambit of 7512. Where the Federal Circuit has gone wrong is by erecting these artificial statutory barriers on what can constitute a constructive demotion. And they're simply not grounded in statute nor in the rest of federal employee discrimination law. So this court should recognize, consistent with, several other courts of appeals, that actions that in practical effect amount to a reduction in pay or a reduction in grade can be a constructive demotion, can be sufficient to satisfy Section 7512. And so here, that's exactly what happened. Mr. Zaharia-Shevitz, he has clearly alleged that he would have been promoted to a GS-15 level if it had not been for the DEA's obstructive conduct. So that is enough for purposes of alleging a constructive demotion to satisfy 75-112. And so in that case, he clearly has a mixed case appeal, even if the court doesn't agree with our IRA appeal theory. So like I said, the Federal Circuit has already recognized that this is an appropriate category within this statutory scheme. And so this court should...
That constructive demotion is an appropriate category, you're saying?
Yes, Judge Thacker. So I think to flesh that out a little bit more, Mr. Zaharia-Shevitz's allegations are clear that were it not for the DEA's obstructive conduct, he would have been promoted. He was placed at the top of several best qualified lists, and he knows that he was the top ranked candidate for at least one of them. Top level agency officials then interfered to prevent Mr. Zahariashevitz from being promoted to that job, and they likely did so on many other occasions. This is enough to allege a constructive demotion, which is sufficient to establish that he had a mixed case appeal. And I think to return to what the Federal Circuit has done here, the Federal Circuit has recognized that where an employee is, effectively would have been promoted because a job classification was elevated to another a higher GS level, and then that employee is transferred away from that job, that amounts to an effective promotion or a constructive demotion. That's the exact same situation as what's happening here. Mr. Zahariashevitz was at the top of a best qualified list, and then effectively, taken away from that promotion that he would have received because of the agency's obstructive conduct. And so that is sufficient to establish a constructive demotion here. So I want to return to the question of the IRA appeal for my remaining time. I think the very important point in this argument is that the statute is clear and the government has not provided an alternative method for this court to interpret the statute in a way that doesn't require this court to contradict the plain language of the text. The government has provided no way for this court to reasonably say that an action through an IRA appeal that can be heard by the MSPB is not an action that is appealable to the MSPB. And most, what the government points to is the fact that these statutory provisions are found in different chapters of the same title, which is just not an effective way of interpreting statutes. And I'll just point the
Ms. Butler, can I ask a question? So you just spent a good bit of time telling us about the Federal Circuit's analysis with respect to constructive demotion and why you think they're correct. And it is the Federal Circuit that more often than not deals with these kinds of cases, since they tend to funnel their way up through that circuit. But I mean, you sort of have to take the good with the bad, because the Federal Circuit has also said in respect to this individual right of action that it's not the type of appeal that was contemplated by the statute. So can you spend a little bit of time talking about why that's just wrong?
Yes, Judge Diaz. I would say, first of all, I did mention the Federal Circuit's decision in the aspect of constructive demotion. I think that there are still problems with their analysis there, but regardless, the Federal Circuit's decision in Young versus MSPB simply just does not grapple with the statutory text. It does not grapple with the fact that 1221H explicitly refers to and incorporates Section 7703B, not Section 7703B1B. It is clear that Congress intended IRA actions to be subject to both of the judicial review procedures set out in Section 7703, both to the Federal Circuit and as mixed case appeals. So when an employee has discrimination claims around the same personnel action as its WPA claims, then Section 7703B2 applies, which puts it in the category of mixed case appeals.
Have you had a chance to review the cases from the 28J letter wherein the Federal Circuit has reaffirmed that position in 3 cases just this year?
Sure, Judge Thacker. I have reviewed those cases, and I don't think that changes the position at all. Like the other cases that the government cites in its brief, it simply relies on Young with no independent analysis. And I think that is the exact situation in which this court should split with the Federal Circuit, because this rule that doesn't make sense with the statute is, being adopted by other courts, including the 10th Circuit, without meaningful analysis, without a clear consideration of what the statute actually says. So this is the exact situation in which it's appropriate for this court to issue a different decision and split from the federal circuit.
Isn't and I don't mean to put words in your mouth, but the argument also, I mean, the whole purpose of the CSRA is to provide a streamlined process for employees to be able to achieve remedies and relief. And it seems like sort of arbitrarily making this kind of distinction it just makes the process much more convoluted and complicated than it needs to be.
I think that's absolutely right, Judge Diaz. And the last point that I'll make before I reserve the rest of my time for rebuttal is that the approach that the government propounds here is exactly the approach that the dissent in Perry asked for, and that was rejected by a majority of the court. And so this bifurcated appeal scheme by which federal employees have to exhaust their claims through different agencies and then to different courts for judicial review was already rejected by the Supreme Court. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, Ms. Butler. Ms. Taylor?
Morning, Your Honors. May it please the court, Laura Rottenborn-Taylor on behalf of the United States and the defendants in this action. I'd like to start where we left off with respect to whether or not an IRA appeal, that is an action under the Whistleblower Protection Act, can form the basis for a mixed case. And as the Federal Circuit has now repeatedly held and the 10th Circuit has also held, the answer to that question is no, and for good reason. The appellant in this case focuses on only one prong of what is required in order to establish a mixed case. A mixed case requires two things, both an action that is appealable to the MSPB, as well as an action, a basis of which is discrimination. As the Federal Circuit has now multiple times explained, and as the 10th Circuit has also explained, a WPA claim cannot, as a matter of law, be based on an allegation of discrimination. And therefore, as a matter of law, it cannot constitute the basis for a mixed case. The definition of a mixed case is found in 7702, and it clearly states that a basis of the action must be discrimination. But in the Whistleblower Protection Act, it specifically disavows that any whistleblower protection claim can be brought based on discrimination.
Counsel, I mean, that's literally true, I guess, but aren't there separate discrimination claims that form part of the plaintiff's allegations in this case? Or what, are you just suggesting that those don't matter?
I am suggesting, Your Honor, that they do not matter for purposes of deciding whether or not the WPA claims constitute a mixed case. In this action, there are two different types of claims that have been brought, Title VII claims, as well as WPA claims.
Right, there's no dispute that a Title VII claim is a discrimination claim, right?
Correct, Your Honor. And a Title VII claim could form the basis for a mixed case if it qualified under 7702. So here we have two different types of causes of action which need to be independently assessed to determine whether or not they can form the basis for a mixed case. With respect to whether or not the Title VII claims could form the basis of a mixed case, they cannot, because the type of adverse employment action here is not serious enough to have appealed to the MSPB directly. And therefore, the Title VII cause of action fails the first prong of 7702, which is that the action must be appealable to the MSPB. The next question is, can the WPA claim constitute the basis for a mixed case appeal? And here, it actually fails the second prong, because a WPA claim cannot be based on an allegation of discrimination. And so the Title VII claim fails the first prong. It therefore cannot be the basis for the mixed case. And the WPA claim fails the second prong. It therefore cannot be a basis for a mixed case. And certainly bundling two unappealable claims does not make the combination of those claims appealable. Mixed case does not mean that you bring causes of action under two different statutes and you bundle them and you get to come to federal district court. Mixed case is a very specific definition found in section 7702. And the Title VII cause of action fails the first prong of 7702. And the WPA cause of action fails the second prong of 7702. And this bears out in the facts of this case as well. And it is important to understand exactly what it is that the plaintiff is challenging. With respect to the WPA claims, the plaintiff claims that he made 4 protected disclosures. All 4 of those protected disclosures allegedly occurred before any act of discrimination. The plaintiff then alleges that he was retaliated against for those 4 protected disclosures. In other words, the WPA claims are entirely divorced from the claims of discrimination. All 4 alleged protective disclosures predate the act of discrimination. The plaintiff then also alleges separately that in 2017, after he made his protected disclosures, the protected disclosures about which had nothing to do with discrimination, he was then discriminated against on the basis of race and gender. And he brings a Title VII claim on that singular incident related to discrimination. Now, what he is trying to get this court to believe is that because he subsequently brought a Title VII claim based on a singular incident of race and gender discrimination, that his prior allegations for whistleblowing related to otherwise unrelated protected disclosures should also be linked with his claim of discrimination, bundled together, and somehow shoehorned into a mixed case appeal.
Counsel, sorry to interrupt you. So I hear your argument. It makes sense. I'm not suggesting that it doesn't, but I think that the argument kind of loses the forest for the trees because it loses it doesn't really focus on the overall intent of this statute, which is intended to provide a streamlined process for employees, federal employees, to be able to get relief. And in most instances, federal employees who don't have the benefit of counsel. And your view of this case, I mean, would require, first of all, to get there, I mean, you literally need to be a lawyer to be able to figure that out. And it ultimately results in this plaintiff and others having to navigate a Byzantine, route of different processes in order to get relief. Whereas your opponent on the other side has espoused a interpretation of the statute, which is consistent, I think, with the overall remedial purpose of the statute. So can you talk about that?
Yes, I'd be happy to, Your Honor. I would start by mentioning as a factual matter that the plaintiff in this case actually was represented by counsel. So he did have the benefit of an attorney. But more importantly, to your question about the CSRA and the intent of streamlining these provisions so that a federal employee can navigate them successfully, the WPA, the Whistleblower Protection Act, is a separate piece of legislation, right? It was enacted subsequent to the CSRA. And it is important here to emphasize that the design of the exhaustion of administrative remedies process affirmatively contemplates that employees who are aggrieved within the workplace may have to file separate complaints with separate agencies who have subject matter jurisdiction and special subject matter expertise over those types of actions. And so the plaintiff here in this case should have from the start, with respect to his alleged protective disclosures and the reprisal for making protective disclosures under the Whistleblower Protection Act, should have brought those claims to the Office of Special Counsel, who is tasked with exhaustively looking at those claims and then deciding whether or not he has a right to appeal to the MSPB. Whereas with respect to claims of discrimination, which again are separate and apart from his reprisal for whistleblowing activity in this case, the plaintiff should have brought those claims to the EEO, who has special subject matter expertise over claims of discrimination. And at that point, the EEO would investigate and administer his claim. And to the extent the plaintiff had any complaint with the resolution of his EEO complaint, then he can appeal either further within the agency or directly to federal district court. But the entire scheme contemplates that different types of claims are from the get-go exhausted with different parts of the agency. And that is to help make the process more uniform. It's to help make the process consistent and fair. The EEO collects data and stats regarding workplace discrimination. It has specific expertise in workplace discrimination, and it would not be efficient or productive for the government to have various complaints of discrimination peppered out over different agencies. Don't we have precedent,
though, that supports appellant's position in the Bond's opinion?
The Bond's opinion certainly addressed both a Whistleblower Protection Act claim and a Title VII claim in the same case. That is correct, Your Honor. However, it did not address this issue. This issue was not presented to it, and it did not address this issue. It also predates Perry, and certainly obviously predates the cases outside of this circuit that have now since addressed the issue. But when a federal employee complains of a
But Perry didn't involve a Whistleblower Protection Act case either, did it?
No, it did not, Your Honor, but it is the seminal decision establishing what constitutes
that was what you were quarreling about Bond's about. And then you use Perry as support, and it has the same issue that you said Bonds has.
That's correct, Your Honor. Perry certainly does not address the question of whether or not an IRA appeal can form the basis for a mixed case, but it does address the question as to what the definition of a mixed case is and whether or not a mixed case.
But that's what Bonds did.
Yeah, yes, Your Honor. To some degree, yes, Your Honor. That's true. This issue as to whether or not an IRA appeal can form the basis of a mixed case was not presented in Bonds, and the court assumed without deciding, because there was no jurisdictional challenge to the IRA appeal, that it was properly before the court. But we absolutely acknowledge that Bonds addressed both a WPA claim and a Title VII claim together. Of course, in that case, the plaintiff had alleged a serious adverse employment action that was appealable to the MSPB, where in this case, our plaintiff has not alleged a serious adverse employment action. Our plaintiff has alleged a non-serious adverse employment action. Moreover, in this case, the plaintiff never sought a mixed case appeal based on his non-promotion. The plaintiff in this case has always attempted to bootstrap his Title VII claim to his Whistleblower Protection Act claim and has alleged that it is the WPA claim that makes his cause of action properly heard in federal district court. The entire heart of this case is whether you can have a claim that would otherwise not be brought to the MSPB and bring it to the MSPB by coupling it with a WPA claim. That would in turn allow every single federal employee who has a non-serious adverse employment action to simply claim whistleblower reprisal, and then suddenly the floodgates would be open to the MSPB. And the EEO would no longer be the primary administrative body to hear employees' claims of discrimination, because the federal employee would skip the EEO and flood the MSPB with these allegations, if all it takes is to claim whistleblower reprisal in addition to a non-serious adverse employment action. And we know that whistleblower reprisal is intended to be a separate statutory construct from reprisal or any other type of discriminatory action under Title VII. The Federal Circuit's decision in Sproul is very helpful on this point because it explains that when enacting the CSRA, Congress chose different subsections to differentiate between reprisal that's based on the disclosure of information and reprisal based on the exercising of a right to complain. Reprisal under the Whistleblower Protection Act simply is adjudicated and resolved through an entirely different statutory construct than reprisal based on discrimination. The EEO is the logical and appropriate place where discrimination claims should be first heard when they're based on a non-serious adverse employment action, whereas the OSC, the Office of Special Counsel, is the congressionally mandated subagency that hears claims for reprisal based on protected whistleblowing activity. I'll also happy to answer any additional questions the court may have. I'll pause here to just emphasize that had the plaintiff pursued his complaint with the EEO, his non-serious adverse employment action, which is of course the non-promotion, could have been easily adjudicated within the EEO and resolved there. And if the plaintiff had any complaint with the outcome of his EEO proceedings, he could have brought that complaint before the federal district court. But the plaintiff, represented by counsel and an attorney himself, did not follow this very clear path for getting his discrimination claim heard. And simply trying to bootstrap his discrimination claim to a Whistleblower Protection Act claim does not save him in this case. And it would open the floodgates to a substantial number of claims before the MSPB that should be more appropriately adjudicated by the EEO. If the court doesn't have any further questions, we would ask that the district court's decision be affirmed.
Thank you, Ms. Taylor. Ms. Butler, you have some time reserved.
Your Honors, I would like to first address the government's contention that WPA claims and discrimination claims cannot be brought together unless it's an action underneath 7512. That's incorrect. If Your Honors would look at 5 U.S.C. section 1221A, It's clear, it states an employee with respect to any personnel action taken as a result of a prohibited personnel practice described in the Whistleblower Protection Act may seek corrective action from the Merit Systems Protection Board. And that provision is very important because it specifically says that an employee can challenge a personnel action. In the Whistleblower Protection Act, in 2302 A2, explains what a personnel action is. It lists various different types of adverse employment actions, such as in a decision concerning pay, benefits, or awards, or concerning education or training. It lists several different types of personnel actions. And then 1221A is very clear that if a basis for that personnel action is retaliatory whistleblower protected retaliation as a consequence of protected disclosures, then the employee may challenge that entire action. Doesn't matter if it's on various grounds. They can challenge that action on the basis of both protect their WPA rights and their discrimination rights, their discrimination claims.
What you read doesn't match your conclusion, Counsel.
I'm sorry.
What you read as the basis for your conclusion doesn't match. You're conflating. You're saying that any separate action beyond the whistleblowing, if it's anything dealing with adverse personnel action, it could be joined.
So
no matter what it is.
I think the way to think about it is, what was the action taken against plaintiff here? Here, we're explicitly addressing, in this part of the case, one instance of non-promotion. That was the personnel action taken against him. He was denied a promotion.
Denied a promotion. Okay.
Correct. And that is
because he felt that he was more qualified than the person who got it. That's right.
Yes, Your Honor. The facts of this case are that he.
I know the facts, but that's the basis because he thought he should have gotten a promotion.
Correct, and that.
And then he's going to join that. He can join that with the Whistleblower Protection Act because he has that extraneous, totally distinct claim and avoid going to ELC.
I don't think it's correct to think of them as totally separate claims. They're both about the same action.
Why is it not correct?
They're both about the same employment action taken against him. And so he can, it was one decision by the board, the DEA, in which he was denied the specific promotion. And then, that constitutes the employment action taken against him. He has multiple grounds to challenge that exact action against him. One is that it was in retaliation for his protected disclosures, and two, that it was also motivated by impermissible discrimination under Title VII. So he can challenge that entire action before the MSPB under the plain text of 1221A. And that's consistent with the Supreme Court's approach and Congress's approach in trying to streamline all of these federal employee actions to a single agency and place for court for judicial review. So when we're talking about the same nucleus of facts, the exact same action, it's clear that Congress, both through the CRSA and the WPA, want those to be channeled into a single adjudicatory proceeding instead of bifurcated in the manner that the government suggests. So I think the last point I'll make is that the government points out or asserts that the plaintiff here could have proceeded before the EEO, and the regulations are clear that he's entitled to elect whether or not he wants to bring a mixed case appeal for the MSPB or the EEO in the first instance. So he was clearly within his rights to proceed before the MSPB in the first instance. And with that, I would ask this court to reverse the judgment of the district court.
Thank you, Ms. Butler. I know the court notes that you were court appointed. I just want to make a special recognition for that. We appreciate lawyers like yourselves who take on these cases. It very much helps the court in doing its work. So we thank you so much. And Ms. Taylor, of course, recognize your able representation of the Department of Justice. We would love to come down and shake your hand, but we can't do so. But nonetheless, we're glad to see you here. Appreciate your arguments and wish you well and be safe. Thank you.
Thank you, Your Honors.
Very much.
Thank you, and may it please the court. The petitioner in this case was accused of a horrendous crime, but the question before the court is not whether he committed that crime or otherwise lacks good moral character. The question is whether the agency violated its own regulations and precedent or the Constitution itself in making that determination. And regardless of what the court may think of my client based on the existing record, the errors committed by the agency were plain and the prejudice was unmistakable. We thus ask the court to remand the case for a new hearing, or at a minimum, to return the case to the board to be reconsidered by a 3-member panel. Before turning to the merits, I would like to address the government's jurisdictional arguments. It is actually an open question whether this court has jurisdiction to consider whether an applicant for cancellation of removal possessed good moral character. But we are not asking the court to review that determination. And even assuming the court lacks jurisdiction over that issue, it surely has jurisdiction over the precise claims, the specific claims that we have raised in this case. Under the INA, this court always has jurisdiction to review questions of law and constitutional claims. Whether an agency violated its own regulations and precedent is a question of law. And whether an agency violated the Due Process Clause is by definition a constitutional claim. So the government's contention that none of our arguments are sufficiently colorable is really nothing more than a disagreement on the merits. Now, on the merits, the first issue we raised is that the IJ violated federal regulations by considering unauthenticated police reports. There is no dispute that the police reports were not authenticated, that a timely objection was made to the IJ, that the IJ admitted the reports notwithstanding their lack of authentication, or that the board failed to cite or discuss the relevant regulation. The only argument the government makes in defending the consideration of the police reports is that we have not specifically claimed that they were fake or falsified in any way. But parties objecting to the admission of unauthenticated documents do not have to claim that they were false or fake or falsified. To the contrary, in the matter of J.R. Velasquez, the board held that unauthenticated documents should not be admitted for no other reason than the fact that they were unauthenticated. Now, tellingly, The government does not rely on the reasons that the IJ provided for admitting the police reports. The IJ denied my client's objection because the records were not being submitted to establish a criminal conviction or a charge of removability. But the regulation at issue, 8 CFR 287.6, applies to official records that are submitted, quote, for any purpose, not just to establish a criminal charge, a charge of removability or a criminal conviction. So there is simply no basis for this court to uphold the admission of the unauthenticated police reports. Now, even if it was proper for the IJ to admit the reports, he still violated the board's precedential decision in matter of Arreguin by giving them full weight. At least two circuits have recognized, the board held in matter of—
What do you mean
yes.
by full weight? The rule is that the IJ could not give them substantial weight or something, significant weight or something like that. You said full weight.
Sure, I meant substantial weight. To give them, the immigration judge gave them substantial weight, full weight, give them.
You can see that the immigration judge was entitled to give them some, assuming they were properly admitted, was entitled to give them the report some weight.
I suppose some, but not as much weight as he gave them. Under a matter of Arreguin would be our position, Your Honor.
And how do we know when it's too much weight accorded to police reports that did not result in a conviction or are not otherwise corroborated?
That is an excellent question, and one the board itself has not provided much guidance on. But I think for purposes of this case, we can say that if you just look at this case on its own, the immigration judge gave it as much weight as he possibly could, and that is more than is permitted under a matter of Arreguin.
Mr. Wintegate?
Yes.
Mr. Dart, I'm sorry. Hypothetical is not this case, counterfactual. If he had been charged and acquitted by a jury, could it still be a basis for determining whether or not he's good moral character?
The board has actually held that it will not look behind an acquittal, just as it will not look behind a conviction to determine a non-citizen's actual conduct. So under the board's precedent, an actual acquittal would preclude the board from, in effect, relitigating the criminal allegations.
So a naked allegation is stronger than a full trial where you are acquitted. What if it was null pros?
What is a null pros?
No, what if the case was null pros?
Oh, the charges were null pros in this case.
What I mean in terms of could you consider the allegations?
Well, I don't think that the IJ has to completely close his eyes to them, as he would in the case of an acquittal.
Then wasn't it really the allegations were the basis for the finding of the lack of moral character?
Yes, the allegations were the base, or basically the sole basis for the finding.
And the witnesses that you wanted to put on, your client wanted to put on, would have confirmed that the allegation was made by the girl, correct?
They would have testified, yes, that the allegation was originally made, but they also, particularly the sister-in-law, would have explained the chronology behind the recantation of the allegations.
They knew about that. They accepted the report. They didn't hear the live testimony, but they took the report, that the letters that were written, and considered those, right? We have to assume that everything was considered in the record, that she made the allegation and that she recanted it, and they say it didn't happen. All of that is in the mix. Your witnesses would have confirmed. This is a different case, seemed to me, if he had said, wait a minute, this girl never made the allegations against me. That's a different question. But you concede that the allegation was made. The allegation having been made, it is in the mix. There's an allegation, recanting, mom says didn't happen. That's in a mix to be decided whether or not it's moral character, isn't it?
Certainly, those things could be considered, but what we're getting into the due process argument, and certainly live testimony is entitled to substantially more weight than written statements. I mean, it's notable that the immigration judge in this case—
Really? Not special. What about you have an incompetent alleged victim? she can't speak for herself. She's incompetent to testify. And she came to her mother, who I guess she loves, and made these allegations. Now, they say it didn't happen. Now, they have to say, well, we'll throw that out now because these two people said it never happened. But the allegation was made by the girl. In your case, your witnesses would have said that the allegation was made, right?
They would have, yes, they would have said that the allegation was made. And then they
say, don't you think that was a factor here? That, like you said, live with testimony is stronger. But the little girl never had a voice. She couldn't have a voice because she was incompetent to testify. She was the alleged victim. Am I wrong?
At the time, she was there's no age limit on when children can testify in immigration court. At the time, she was 9 years old, and I think all parties would have frowned upon bringing her into court. She is now 12 years old, and I am told that if the case is sent back for new trial, that she would be willing to testify in my client's favor. That's what I've been told. But with respect to the sister-in-law, pardon me, the IJ, well, so the reason the IJ provided was that, the only reason the IJ provided was that they did not, my client's former attorney did not provide a witness list. But we think that's actually protectual for a few reasons. First, the IJ was put on notice, this is on page 591 of the record, that the wife and sister-in-law were prepared to testify. More importantly, the government not only waived any objection to the absence of a witness list, but the government themselves wanted my client's wife and sister-in-law to testify so that he could cross-examine them. And then third, as I was saying, written statements, the written statements in this case are very brief. They are written in, I think, what may be called broken English, and they really do not go into the allegations at all. So if in terms of prejudice, if you compare the testimony that would have been put on in this case to the testimony that would have been put on in a Temken, we think this is the test in a Temken is simply whether the testimony would have added something probative that was otherwise missing from the record. And here, the sister-in-law's testimony.
Sorry.
Yes, Your Honor.
Yes, here to follow up on the Chief's questions. But as I understand your position, it's not just that the allegations were made. I mean, the IJ ultimately has to make a determination in assessing good moral character where there is some truth to the allegations, right? And the whole basis of admitting the report was to corroborate the substance of the allegations. And the report included not just the narrative of the investigators who talked to the victim in this case, but also, as I recall, a telephone conversation in which the petitioner allegedly made admissions that, obviously didn't cast them in the best light. Isn't that the problem here, that there's just much more than a mere allegation? The report just kind of puts it all together and ties a neat little bow for the IJ to consider. And the problem with that, as you pointed out, is that report never should have come in to begin with.
That's completely right, Your Honor. And we think not only should the report not have come in, but if the court finds that it was correctly admitted, that makes it all the more important that my client's witnesses have been given an opportunity to testify. This case was the equivalent of a criminal trial in which the prosecution is allowed to put on its case, but the defense is not allowed to put on its case. Conceitedly, my client was allowed to testify himself, but his corroborating witnesses were not allowed to testify.
Well, because they weren't on a witness list in the first place.
They weren't, but as I said, the government waived its objection to that. And even if they were on a witness list, it's clear that the IJ would not have allowed them to testify in any event. And we know this because he set 4:30 p.m. as a hard cutoff time. And my client finished testifying at 4:20 p.m. So we think even if a witness list had been submitted, the IJ made clear that he would not have allowed any further witness testimony.
I don't understand. Didn't you have 3 hours? Was it 3 hours?
There were 3 hours total. He said 3 hours, so I don't know exactly when the hearing started.
Right. What took so long to put on these star witnesses?
I think the reason, Your Honor, is because my client testified through a translator, and that just takes twice as long because all answers have to be translated. Questions have to be translated from English to Spanish, and answers vice versa.
It's interesting because I used to be a defense lawyer. I did a lot of criminal defense work. You normally put your client on last because you don't know what your supporting people are going to say. And so you always put them on first. So you waited 2.5 hours before you tried to even put them on, and they were on. These people were like linchpin witnesses. It didn't matter about him. I mean, I would put him on based on this case like 5 minutes. What's your name? Are you a nice person? Yes. Blah 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 blah. But I just don't understand why these people weren't proffered. Said, Judge, we're starting this thing. We're ready to go. Here are 2 witnesses. Boom. Why was it almost at the end that the judge was saying, well,
Sure.
I'm cutting this thing off here. I know that rubs any defense lawyer to do that. Mm-hmm. But can you tell me why these people were so important? Why weren't they put on?
In immigration court, Your Honor, it is customary for the respondent to testify first when they're seeking relief from removal. That's simply a matter of custom. And I think it's in part because it is the respondent's burden, and the IJ has to make a credibility determination whether they believe their own testimony and whatnot. But certainly from a strategic standpoint, it may have made more sense to call the other witnesses first. I will grant you that. I would note that there was another argument I would like to touch on before rebuttal, and this is the final argument we raised, and one that would actually allow the court to avoid reaching all of the other issues in this case, and that is under the board's own regulation, a single member should only decide a case that is capable of being resolved by a brief order and should instead refer to a 3-member panel any case that involves a, quote, complex, novel, unusual, or recurring issue of law or fact. Now, the board's decision in this case was not brief, and the issues are indisputably complex, novel, and unusual. Now, the government's primary argument is that we have no right to challenge the board's failure to refer this case to a 3-member panel because the regulations do not require any case to be referred to a 3-member panel. But this court rejected that proposition in Contreras-Mendoza, where it noted that the regulations suggest that if a case does meet the standard for adjudication by a 3-member panel, a single member shall not decide it. And taking the government's argument to its logical conclusion, the court could never find that the board should have referred a case to a 3-member panel, which would conflict with Contreras-Mendoza. And we also think returning the case for further consideration by a 3-member panel would allow the board to issue a more comprehensive decision. The board's prior decision did not cite or discuss the authentication regulation. It did not cite or discuss the matter of Aragin. And it didn't mention the fact that DHS affirmatively requested that my client's wife and sister-in-law be allowed to testify. So at a minimum, remaining the case for further consideration will allow the board to issue a more developed decision.
Thank you. Ms. Winograd. Ms. Ramnitz. Mr. Ramnitz.
Yes. May it please the court, Your Honors, Tim Ramnitz on behalf of the United States Attorney General. In this immigration case, petitioner challenges the agency's discretionary determination that he lacked good moral character for purposes of cancellation and removal based on allegations made in an investigative report, reporting that essentially he was alleged to have committed sexual abuse of a minor. Now, petitioner, at the top of his argument, did not challenge that discretionary bar to review at 1252A2BI applies to good moral character determinations. He noted the court, it's an open question, it's only addressed in unpublished decisions, but he said he's not really challenging that the bar applies, but he's arguing that the court has a jurisdiction to consider it as a question of law, the weight the agency afforded to the allegations in the police report. But as this court explained in Sorcia, which is a 2011 case, which both parties cite, when someone challenges the weight afforded to factors in discretionary relief, they're not alleging a question of law. They're simply disagreeing with how persuasive the immigration judge found the evidence.
Well, counsel, you kind of skipped over the threshold question, which is you don't get to the weight of the evidence if the evidence never should have been admitted in the first place. That clearly is a question of law. So I mean, the board didn't even cite the regulation. The judge in this case didn't pay any attention to the regulation. And it seems pretty clear that on the face of the regulation, there's no exception that would have allowed this evidence to be admitted once a proper objection to authentication was made.
I don't believe there's a question of law here, not a meritorious one. And I do believe the immigration judge considered that regulation. And it's the immigration judge's opinion. He talks about the authentication regulation that petitioner argued, 287.6, and states that under matter, it doesn't cite matter of J.R. Vasquez, but petitioner does and the government does. This is a decision that really explains why that regulation is not applicable. That regulation needs rote adherence to when you're trying to prove a criminal conviction. Matter of J.R. Vasquez, which petitioner really hammers on, says twice in two different footnotes, this regulation does not apply in the discretionary relief context when we're looking at conduct and not conviction. So it's really a red herring that petitioner presents. This regulation, that's why the immigration judge so quickly disregarded it, does not apply to conduct and discretionary relief. J.R. Vasquez walks through how Congress made this really applicable to establishing convictions and the purpose of removability when you have to, as the court is probably really familiar with, the categorical approach and establishing the fact of a conviction.
So you correct me if I'm wrong, and I don't have the case in front of me, but wasn't matter of Adagin also a matter of discretionary relief? And the board there indicated that the use of unauthenticated evidence was improper there?
Not unauthenticated. The board said uncorroborated in that case.
Okay.
So we're getting past this authentication issue, which I think is a good thing, because that's why the immigration judge quickly dismissed it. Just simply not applicable. And I also know, just the last thing I have to say on authentication, unless the court has further questions, is that under Yanez, this is a 2015 decision from this court, and I can provide the court citation. It specifically said these regulations under HCFR 287 do not create enforceable rights. These are simply internal guidance. So not only does authentication regulation not apply here, it doesn't give any enforceable rights for petitioner. This is just simply an internal.
So it's not, I mean, I hate to say this, but you seem to be saying that it's not worth the paper it was written on. First of all, the regulations doesn't make the exception that you talk about, doesn't make the distinction between discretionary relief and other forms of relief and the merits of a conviction to begin with. But it can't be that it has no meaning whatsoever. And surely if it has some meaning, then a petitioner can, in fact, exercise an objection when it's appropriate. You're taking issue with the scope of the relief that's awarded under the regulation, or that might be available under the regulation.
Well, what I'm arguing is that this is a regulation that the agency passed, and the regulation the agency has interpreted in matter of J.R. Vasquez. It said that this doesn't apply in this context. And that's what the agency has said for a long time. The petitioner really glides past that when he ever talks about matter of J.R. Vasquez, that it specifically said, we're not applying this regulation when it comes to conduct. So we passed this regulation. This is how it applies. That's what the agency has said. And when you look at the decisions that both the parties cited interpreting this regulation, they've always made note of the fact that under the federal rules of evidence in this regulation, it doesn't provide to be exclusive means of authenticating a document. The courts have said over and over again, and this is not in immigration proceedings, the exclusive means of authenticating a document. Whatever tends to show the document is what it purports to be, authenticates the document. And that's why I described this argument as a red herring, because the petitioner never argues this is not what it purports to be. And even in the petitioner's testimony, he said these allegations happen.
Okay, well, there you're kind of flipping the burden, right? You're saying that because the petitioner didn't indicate or prove that it wasn't what it was purported to be, then his claim fails. But it's the government's burden in this case to show that the document is what it purports to be, isn't it?
We have to show, to admit a document, this is apart from the regulation, to admit any evidence that both parties ever wants to offer for admission, has to show it's probative and that its use is fundamentally fair. That's what the government has to show. There's certainly no debate this document is probative as good moral character. The second, is it fundamentally fair to admit this document? It certainly was in this case because the petitioner had an opportunity to fully confront this document. That's what the government's burden is in these cases when it comes to admission of a document. I'm trying to raise this regulation, which is simply not applicable. It's nothing. It is a red herring. Nothing that a court has said is specifically applicable in this context. And the board has stated it actually the opposite. It is not applicable in this context.
Okay, so assuming it was appropriately admitted, the report, it appears that the IJ not only gave it substantial weight, but sole weight. What other evidence did the IJ consider in determining the lack of good moral character here?
This was the determinative factor in good moral character, the allegations, this investigative report. That's why the immigration judge found petitioner lacked good moral character. He
So then
described-
how does that not violate the precedent that it should not be given substantial weight?
Does not violate that precedent, because if you look at matter of Aragon and the other two decisions of petitioner cites from the 6th and 7th Circuit, Avila in the 7th and Bekele-Tolosa in the 6th, what's most important and what the courts emphasize is that petitioner's testimony, where he asserts no wrongdoing, was afforded full weight as well. He credibly testified in each of those cases to no wrongdoing. And so that's why the board declared it was error in matter of Aragon, because you had.
But in those other cases, there was other corroborating testimony, wasn't there? One from a social worker, and I can't remember which case, but.
Yes, and that was the 6th Circuit case. The immigration judge appointed a social worker, and the social worker said, I agree with petitioner of his claim of no wrongdoing. And that's why the immigration judge found it was a credible claim of innocence. And that, when you have a credible claim of innocence and allegations, and just have a police report, then the court has said that might be error, because why would you just choose one over the other? You're not really explaining why. And that's not what happened in this case. The immigration judge heard petitioner's testimony and found it not persuasive, and for very good reason. Petitioner had implausibly claimed that he was never alone with this little girl who made these allegations. And even though he said at the same time he spent every weekend with her and her family, they went on trips together, and he said he was never alone with her. And then when it came to refuting events described in this investigative report, he simply kept falling back and saying, I don't remember, I don't know, I don't remember. The immigration judge looked at that and found that not very persuasive in comparison to this investigative report, which I would note is not simply an arrest report, as we see a lot in immigration proceedings, where the report details how police picked this person up and then he was charged. This is a detailed investigative report that is internally corroborating it.
Okay, so that's so fill in the blank, I guess, for me. The precedent says the IJ cannot give substantial weight to a police report where that didn't result in a conviction. Here you say the IJ gave sole weight to this police report, or at least petitioner says, and I thought I heard you agree. So why, again, does that not run afoul of precedent?
Because in all those precedents, petitioner had a credible claim of innocence. It was found to be credible that in all those cases, and the 7th Circuit case specifically highlights this fact that his testimony claiming innocence was found fully credible by the agency. That's not what happened here. You have basically what the agency found is that we have a police report, an investigative report on one side, and really nothing on the other, because your testimony claiming innocence was not very persuasive. In all these other cases, the testimony was afforded full weight. And as you noted in the 6th Circuit case, there was also a social worker who said, I also agree his testimony claiming innocence is worthy of full weight. And that's not what happened here. We have a very thorough investigative report the petitioner simply could not explain. And that is why, in this circumstances of this case, it doesn't run afoul of any of those precedents, because it's just different. And there's
Can I go back to Mr. Counsel to your argument about authentication? And I hate to beat a dead horse, but you cited to Inre Velasquez. I didn't have the case in front of me when you were reciting it, but even in that case, as I read it, the BIA is not suggesting that some form of authentication isn't required. It's simply saying that the precise methods of authentication described in the statute and the regulations aren't mandatory or exclusive, but there has to be some form of authentication of the document. And the regulation on its face doesn't make any distinction between its use for to prove a conviction or to afford or deny discretionary relief. It just says if an evidence is used for any purpose, it has to be authenticated in some way. And you still haven't told me what the government did in this case to authenticate this evidence.
Well, what the government did was present this evidence, and petitioner has never claimed it's inauthentic.
That's again inverting that's inverting the burden. That doesn't make any sense.
What I'm trying to say or explain is that if the document was submitted and what petitioner is arguing for is rote adherence to this authentication regulation without actually.
Well, sometimes rote adherence is important. Process is important. The whole purpose of this procedure is at least to adhere to some minimal standards of due process and, you call it rote, but I think it's much more than that. And it wouldn't have taken much in this case for the government to bring in somebody, an officer, somebody, a certification by the state agency to authenticate the document. But there was nothing done here.
Well, perhaps that would not have been a large burden on the agency, but there was really no reason to, because as petitioner admits, he's not claiming this document is not what it purports to be. He doesn't say that anything in this document was unreliable. He simply wants strict adherence to this regulation. And as we just read in matter of J.R. Vasquez, strict adherence to this regulation is not required. All that's required if someone challenges authentication is that its document is what it purports to be. And petitioner is not challenging that it's actually inauthentic. He's just challenging the regulation wasn't followed. And the regulation is not required to be followed in this case. It just, the government has to submit probative, fundamentally fair evidence. And it's not fundamentally unfair to submit this when petitioner actually doesn't claim it's inauthentic. And petitioner's testimony too.
So is there a subtext in your argument there that because the petitioner is not claiming that it's not what it purports to be, petitioner is not prejudiced by admission of this police report?
Yes, I'm saying that all these arguments about adherence to regulation, it's not an error and it's not prejudice. It simply has no application in this case. Petitioner doesn't challenge that these allegations didn't happen even, as the panel has noted. He says the allegations happened exactly as reported in the report. He just simply says the whole time this little girl was lying. So he really wants just strict adherence to regulation. It's inapplicable. Meanwhile saying, but yes, I admit that everything is fine about this document. It happened, it's authentic. And that's why his argument just collapses, because there's no need for rote adherence to that regulation, as the board has said so.
Okay, so, and I think you were responding to Judge Thacker's arguments while I was looking something up about the weight that was given to the document. So why isn't the fact that, I mean, this was it was a report, and that's essentially all that the IJ relied on to give it dispositive weight. Why isn't that inconsistent with the board's precedents?
It's not inconsistent with the board's precedents because in those precedents, there was full weight according to petitioner's claim of innocence. Petitioner was found to credibly say in matter of Erickman, he was found to credibly say in the Sixth Circuit decision and the Seventh Circuit decision that I'm innocent. In fact, as the panel pointed out, in the Sixth Circuit decision, a court-appointed social worker, an independent person, agreed with the petitioner saying, I believe he's innocent. That's what the difference is. In this claim, the immigration judge weighed this testimony claiming innocence and found it wasn't credible. It wasn't persuasive because petitioner.
Well, he waited, by the way, he waited in the context of a proceeding in which that was it. It was a paper record. The witnesses who were apparently available to testify weren't allowed to testify because of some slavish adherence to a deadline, a time deadline.
I don't believe it's slavish adherence. I mean, this is a docket management tool. Petitioner, if he really thought these witnesses were so significant to his case, surely would have gotten them together earlier and presented this witness list to the immigration judge. The immigration judge provided 3 hours for this hearing.
Well, there was no objection to on the basis of the witnesses, and if I recall, the government wanted the witnesses to testify, I guess in part because they thought that they'd be able to poke holes in the story of the witnesses. Isn't that right?
That's correct. In DHS's closing statement, it said we'd be more than happy to cross-examine the alleged victim's mother in this case, based on her letter where she describes being confused about things. They want an explanation on that. If they were happy to do that. However, it's still within the immigration judge's discretion, as any judge's discretion, to manage their docket appropriately. And the immigration judge stated that I provide you 3 hours, and the last minute you stick me with 2 more witnesses. That just can't be done here. Maybe there's to be time, but that's really not something that I have to allow you to do. And it's within the immigration judge's discretion. It was within the rules, as the Immigration Court Practice Manual states, you have to submit a witness list for the very purpose that you have to know how long the hearing is going to be. And so if you really want to present these witnesses, I mean, maybe it's a claim of ineffective assistance of counsel at best that this attorney didn't get these witnesses together if they were so significant to their case. But it's not any error on the immigration judge. Unless the panel has any further questions about this case, the government will see the rest of its time.
Thank you, Mr. Ramnus.
Yes.
Mr. Winograd, right?
Thank you, Your Honors. Just very quickly on jurisdiction, to be clear, we do dispute that the jurisdictional bar in 1252A2B1 applies to the good moral character determination, but we simply haven't raised that issue because it's not before the court. We're not asking the court to review the overall determination. And in any event, there is a case currently pending before the Supreme Court, Patel, which was argued in December. We discussed it in footnote 1 of our reply brief. And based on the argument, it seems as though the court is poised to agree with our interpretation of 1252A2B1. But again, that's not before the court. With respect to authentication, I would first point out that the board did not rely on any of the arguments that the government is now making. The board did not even cite the regulation in question. So we think this is simply all a post hoc rationalization that this court cannot consider under the Chenery Doctrine. But in any event, the text of 287.6, as Judge Diaz noted, admits of no exceptions. It refers to official records when admissible for any purpose. Likewise, matter of J.R. Velasquez does not say what the government claims it says. On page 684, the holding is, we conclude that the disposition notice proffered by DHS as proof of the respondent's conviction is not admissible into evidence because it is not authenticated at all. Here as well, the police reports were not authenticated at all. Now, with respect, yes.
How would they be authenticated in this case?
How? Oh, with a seal from the agency or simply a letter or email establishing chain of custody, something like that.
So if somebody just stamped it, that would have been it, right?
Yes, I mean, that's how conviction records are authenticated and certified. It's from a stamp bearing the seal of the clerk. Now here it's from the police department. So
because that's when there are predicate offenses that are required as elements, what they're charged with, those things like that. But here, this is a discretionary relief. And the question is whether or not there's moral character. The thing is that the witnesses that you brought that will testify, aren't they the same witness who brought this charge? I mean, who made these complaints? The little girl didn't find her way alone, did she? Aren't they the ones who, or somebody, right? Correct?
Yes, my client's sister-in-law was the one who contacted the police, but she did so believing that her daughter was telling the truth. Once her daughter admitted that she was lying, she then called the police to recant. Basically, her and her daughter appeared before the police and the prosecutors to say that we wish to withdraw the charges because the allegations did not, in fact, the allegations were made, but the conduct in question did not, in fact, happen.
That witness could have been called, right? The police. You could have gotten a statement from the police who heard her say that's not true.
Actually, my client asked to cross-examine the police, but the government said, again, this trial happened in the middle of COVID, that it was simply too difficult to bring the arresting officer into court to testify.
Postponement.
Well, the immigration judge made clear that he was not continuing the proceedings. He makes that absolutely clear that he was going to issue a decision that day. So yes, for all intents and purposes, any request for a continuance would have been denied.
I'm trying to get this for discretionary relief in this situation here. Even if, for example, even if she later said, what the girl said, I didn't tell the truth, I was lying. That's what you purport that they would have said that she said, right?
Not only that, but the sister-in-law would have testified that she fabricated the entire account of the initial confrontation at my client's home. So if she had been called to testify, she would have said, when my daughter told us, we did not, in fact, go over to my client's home to confront him. She would have testified that she made that up in an effort simply because she was so mad at him based on what her daughter told her.
Okay.
So it's not simply a matter of her confirming that the girl now retracts. It's that she herself the sister-in-law herself embellished the allegations. That is what she would have testified had she been allowed to testify. And to address your larger question, I mean, the good moral character determination, it's a balancing test, if you will. And our ultimate argument is that the IJ allowed the government to put evidence on its side of the scale that should not have been admitted and prevented my client from putting evidence on its side of the scale that should have been allowed to come in.
Can this court order the government to find Good moral character?
Well, again, that is an open question. Whether good moral character is something that this court has jurisdiction to consider, that's an open question. For example, this court has held that whether an applicant for cancellation has established exceptional and extremely unusual hardship is a mixed question of fact and law over which it does have jurisdiction. So by that token, that's the Galvan case, Galvan. By that token, we would also argue that good moral character is a mixed question of fact and law, which this court would have jurisdiction to review. But again, because the scales in this case included evidence that should have been admitted and did not include evidence that should have come in, the court is simply not in a position to make that determination.
What about voluntary removal?
Voluntary departure? That voluntary voluntary departure.
I'm talking about Fourth Circuit jurisprudence.
Sure. Has both statutory eligibility requirements and a discretionary component. Good moral character, at least for post-conclusion voluntary departure, is an element, is a statutory element, and we would argue in that context as well that it is a mixed question of fact and law. But voluntary departure, like cancellation of removal, are discretionary forms of relief. So at the very end, even when a non-citizen has satisfied the eligibility requirements, the IJ must make an ultimate discretionary determination. And I would note in this case, the IJ did not make that determination. If you look at the last paragraph of the IJ's decision, this is on page 75 of the record, he specifically declined to determine whether my client would merit a favorable exercise of discretion because he did not satisfy the statutory requirement of possessing good moral character. If the court has no further questions, thank you.
Thank you so much. Thank both counsel for your able arguments. We can't come down and greet you. We certainly can't do it for the government. But nonetheless, that we appreciate your arguments and wish you well. Be safe. Thank you. With that, we'll ask the clerk to adjourn the court for this afternoon. Right?
This honorable court stands adjourned. God save the United States and this honorable court.
Judge Gregory.